Today we're going to discuss about the travel ban and the national interest exceptions that are available for the people and how to navigate the travel ban if you fall into that particular category. That's the main topic for us. We are also going to discuss about the Ombudsman annual report to Congress about the function of the USCIS. We're going to discuss about the H-1B applicants that file lawsuits challenging the way that the fiscal year 2022 H-1B lottery registration rules have been set up and applied with. We're going to also discuss about the DS-160 form that you fill out when you apply for a non-immigrant visa, how important this DS-160 is, how it becomes a part of your entire process. We're going to discuss about this. Emily, on the travel ban, we do expected, by July 4th weekend we'll be COVID-proof, and why are we not taking the travel ban put for the COVID?
Well, if you think about it, we've had all of these travel bans have been, besides the one from India, have really been in place for a year now, and we still have them. So the India one is a new travel ban, and if people were expecting that it will be lifted as soon as the COVID situation gets under control, I think with today's announcement of the national interest exception validity period being expanded is a good indication that they don't plan on lifting this anytime soon. Why would they need to expand it for an entire 12-month period if things are getting better? So it's a good news, bad news situation. The good news is once you get that NIE, it is valid for 1 year, and those people who already received it, it's retroactive to the date you received the NIE, so it's valid for 12 months from that date. And you can use it for multiple entries. You can go in and out a number of times once you get the NIE. Bad news is, why are they issuing it for 12 months? Maybe they're expecting that this is going to be a continued travel ban for some time.
So Emily, if I got the H-1B approval right now and then I want to go out to stamping, can I go to India and get the stamping? If I get a letter from my employer that I fall into the national interest exception, how comfortable will you be to send your client?
I tell people do not travel. Even if you think you might get an NIE, unless it's a life or death situation, if you're already in the U.S., you should stay put, because these travel bans and these exemptions, they're being updated all the time. And number one, you can barely get an appointment. You have to qualify as an emergency situation just to get an appointment. And then once you get the appointment, there's no guarantees that you're going to be issued the NIE. It is discretionary, and it's up to the officer during your visa interview to decide whether to grant that or not. So I would not be relying on that, especially if my travel is not absolutely necessary.
Emily, what if I am on H-1B here, my wife is in India, and she has to apply for the H-4? What should they do to apply for it? And of course, we don't have a U.S. citizen children.
Yeah, the NIEs are generally geared towards when the H-1B holder, for example, or the L-1 holder receives the NIE, then the spouse also receives it. But if only the spouse is the one that's traveled, unless there's some sort of humanitarian reason why they need to give an emergency appointment and grant the visa, I think you may be stuck for some time.
Emily, what if I'm stuck in India right now? I have an H-1B right now, and my employer believes that we fall into the national interest exemption. What is the process involved in it? Right now, the online appointments are not available. What do I do?
Yeah, so for each consulate is different in how they're doing this, but for the consulates in India specifically, they're asking you, number one, you have to fill out the DS-160 online, pay your visa application fee, and then you book an appointment, book the first thing that's available, even if there's nothing available until March 2022, and then you will be given the option to request an emergency appointment. In that request, you fill out the information, provide the basic information explaining the need for the emergency and that you think you qualify for an NIE, and submit that. Then you have to wait to hear back from the consulate of whether they're going to grant the emergency appointment. If they do, then you have to plead your case at the visa interview appointment with the documentation from your employer.
Before I go to the next topic, though, I just want to point out that those people who have questions about the birth certificate, we have a separate video. We put it in there. You can read that thing. We strongly recommended last week, and I hope so this will continue, that we want every one of you to write letters to the US, to your congressman, to use the green cards that we've been given, extra green cards for the employment based. Otherwise, most of the Indians have to wait extra 26 years if they don't give the green card. We want every one of you to write a letter. The drafts of those letters have been put at the link that we have provided at the bottom at the Immigration Girl, which Emily wrote in the blog. You can use it, contact the congressman, write a letter, send a copy to Congresswoman from San Jose, whose name is Joey Lofgren. And also we want to question the State Department, how they're moving the dates. When they know that they're going to waste the green card, why can't they make everything current like the way they did in 2007? There are very good questions that Emily has put in her blog. We want you to send those emails to the State Department, and the subject matter should be as what is left in the link there. So if you ask those questions, we will get the priority, because last time they received 470 questions or so. So they take the most common questions. So we want you to ask these questions so we can use these things. Don't forget that if you want to use our services, for example, if you want to pre-prepare your application for 485 application, we can help you out. There is a little bit amount we charge in advance right now, and the full amount is when the priority date becomes current. We have provided link at the bottom where you can use and to inquire about our services. We also given for the birth affidavits, the format of the birth affidavits, also we have given a link for that one. And if somebody wants to do the medicals, we get a lot of these questions. My lawyer is telling me not. It's up to you whether you follow them or whether you follow us. Remember that they told that you cannot downgrade the application, the new application, and file it as I-140 new. They have been proven wrong. They said I-140 premium processing can be converted after you do the downgrade. They have been proven to be wrong. So think of all the things, though, that these people don't have experience. What loss you're going to get? I don't care about your $200, $300. If you do care about those things, definitely don't send the medicals. But if you want to, there's a link provided in there. Please don't call our office and argue that, hey, you are wrong. It's up to you. I mean, it's just like the way, the blue color or red color. You like red color, I like blue color. Nothing wrong with it. This is our choice. And if you don't do it, you're nothing wrong. It's just our strategy in doing it. So all those links are provided there. Please use, especially the letters to the Congress people and also to the State Department. We urge you to do it. We see a lot of people sending us emails, sending us YouTube, telling that they have written the letters. We definitely give priority for those people who have sent the letters and who promised to send the letters. We're going to give the priority for them to take the questions in this one and in the coming thing, because we want you to be proactive in those things. These are the things. And there are some people, oh, I wrote a letter because of you. Do a favor and do a free consultation. I mean, we understand you did a good job, but it's good for you. I mean, I already got my citizenship. I don't know if you know that or not. Emily is a born citizen. I am already a citizen. This is for your benefit. We want you to write these letters so that you get benefit. Yeah, of course, obviously, your benefit is my benefit, and Emily's and our office benefit too. So please write letters. Don't expect any favors from us if you wrote a letter. This is for your benefit that we are trying to do. So please avail our services, but don't expect any favors from us. Emily, on the Ombudsman annual report, I was not happy with the report that they said blaming COVID for everything.
Yeah, that's their response behind why processing times are horrible, why they can't seem to figure out how to do electronic filing, just everything, delays in giving receipt notices. Can we really blame COVID for everything, or did they not actually have an emergency plan in place, and did they not have a plan to use the fees that they receive in place? I don't know what they're doing.
Fees definitely is an excuse. I don't know how Ombudsman is supporting the fee structure there, though. The last Ombudsman, did differently, though. He took the fees off for the year in advance parole. That was Prakash Khatri, is a good friend of me. He was the first ombudsman that was appointed by the Bush administration. He took the year in advance parole fees off. Now this ombudsman want to keep it back. So I don't know whether I'm happy with the report. It looks like the USCIS prepared the report rather than Ombudsman, who's supposed to be in between us and the USCIS that prepared the report. There are many things. Technology has moved 10 years ahead thanks to COVID. People have moved on. There are a lot of different things. Companies have adopted online things, integration things. People have moved to the technology. They have used COVID as an excuse to advance. Now it's going the other way with the USCIS. Fingerprints, biometrics that happen for 4-year-old kids. What are we going to do with the 4-year-old kids? What crimes they would commit? I don't know. These are all the things. Biometrics have been imposed. 485 interviews have been initiated, which was not there. They didn't address most of those things. They addressed just COVID. Mm-hmm. I was not impressed, Emily.
Yeah, and especially we've been talking about this idea of transformation, moving to electronic filing for 15 years now. And look how far we've gotten. We can file an OPT application online and an I-539 application online. Now in this report, it's claiming that they have to have a plan in place for electronic filing of all applications by fiscal year 2026. What have we been doing for the past 15 years if we still don't have anything?
Wait. Emily, I'm having some problem. Are we living in United States of Banana Republic? Are you living in United States of America? Where am I?
Yeah, I mean, looking at this, you have to wonder why they're having such a technological issue when this is the best time for technology that we've seen, and remote this and Zoom that. Why cannot USCIS figure it out? The Labor Department has even figured it out.
That was 15 years ago. Sorry, that was 2003, 2005.
Yeah.
2005. 16 years ago, the Labor Department figured it out. Well, LCA thing was a little bit before. Perm labor certification was 2005. Why not? Why can't they move everything to credit card? Why can't they move online payment system? Simple forms, simple things. They complicate it so much, and they want more fees for what? To complicate it more. So definitely I was not impressed with the report. We would like you guys to contact the congressmen. We just don't want them only to see this report, because remember, the Congress office reads this report much thoroughly. Not every congressman will go through all the pages, but the people who are in charge of the immigration in those Congress offices will read these kind of reports. We want you to write the letters. And one of the letters that we drafted, and we'll keep on drafting letters for you, please go through those things, because we see you much more than anybody else. We are not YouTubers. We are not just we are practicing lawyers. We do hear the clients. We do speak with the clients. We handle the cases. We know the difficulties that are coming for you. We know the difficulties of the USCIS too. So we see all those things. We draft all those things. We want you to avail these services, to draft use the draft letters and send it. Make sure that the Congress is heard. We definitely want you to contact Ombudsman's office if it crosses the timeline which is prescribed in there. God knows it's between 12 months to 15 months for 485 application. Why is it like that? It didn't used to be before. When the first Ombudsman came in, it was Prakash Khatri, is a good friend of me. Maybe we should bring him on the show one time. And then he brought the whole thing down. It used to be a lot of delay, 4 years to get the 485 approval. He brought it down to, in most places, 4 months. We begged him, don't do 4 months. We couldn't get the family, especially the family immigration. We need to have living together documents. They are going 2 months, 3 months, 485 application approval. We said, don't approve so fast. At least have it to about 4 to 5 months so that we can collect the documents. That's how it was. And now we come this ombudsman. Oh my goodness. Looks to be that they are part of the USCIS than being an ombudsman.
Yeah, hopefully we'll see some improvement. I mean, I think part of this report covers the Trump years and a different ombudsman during that time, and we do have a new ombudsman now, so hopefully we will see some improvement. But they're basically citing to the lack of fees, and they're still claiming there's a huge budget shortfall and they need to increase fees in order to provide better service. We just want service at this point. It's not about better service. Just provide us the basic service at a reasonable fee before we start talking about increasing fees to provide better services. And now they're saying, oh, well, if we add premium processing to all of these different filings like Congress said we could, the regular processing times are going to get worse because they don't have the capacity. Premium processing is very labor intensive to get it done in the 15 days. So it's like they're already coming up with excuses why they won't be able to make improvements even after getting this additional premium processing money.
And that to $2,500, that's a lot of money. Emily, what about the lawsuits challenging the fiscal year 2020? Do you think so it's going to stand? What will happen? Is it going to go back or is it going to go forward, just in case if they win?
So, yeah, I think what they're trying to do is get the current electronic registration process regulation thrown out. I think that the difficulty with this lawsuit is what they ultimately want is one registration per person, because the statute refers to alien. The cap should be given out to each alien, not electronic registrations. And their concern is when people are able to submit multiple registrations, or you have companies that are fraudulently submitting registrations and USCIS is doing nothing about it, which I agree with. That's a problem. However, we've had this lottery going back to 2013, and from the time before when it was not an electronic process, people could file more than one petition with the same employer or with different employers. So this idea that the electronic registration should be thrown out because it allows one person to submit multiple registrations, well, then we should have been having this argument going way back to 2013 and then in the prior years before that.
Although I differ with you a little bit there, Emily. Let's say, for example, one crooked guy thought about going to 10 fraudulent companies and file with 10 fraudulent companies, then they have to shell the money and the money is gone. Here, what money are we speaking about? $10? They don't care. Who cares about $10 nowadays? Especially the people who, IT sector people, they don't. So that's definitely a thing there. I think so there should be electronic registration, according to me, but it should be restricted to only one person, as you said, alien not. They should not be allowed to file multiple things with the loopholes that are available. Maybe they should close a loophole of having multiple applications with different employer, because that will discourage the fraudulent activity going on, Emily. That's the way I feel. But even if the court comes out negative on this one, I'm not expecting that they're going to go back to the existing H-1B applicants and then they will say, oh, you're not selected in the lottery. I'm not expecting. It's going to be only going forward they will do. That's what I'm expecting, Emily.
Yeah, I agree.
On the DS-160 non-immigrant visa application, this is the most common thing. We are ending into trouble. Those people who file the 485 applications, those people who are filing the I-140 applications and H-1B, if there is any contradictory information about their employment history, educational thing, and they are telling a different story at I-140 and 485, you may be in trouble. There's a lot of debate that happened in our office whether you should report the voluntary jobs that you have worked on. At this point of time, it's very, we are unable to decide whether you should we should report or not report. We will, we'll keep updating you on that. But one thing is for sure, though, be consistent. If you have reported any voluntary job, be consistent all along, including your labor certification, including your I-140, including your 485. But if you have not reported the voluntary job, don't report it. I mean, that's our suggestion. Any corrections on that, Emily?
No, agreed. Yeah. So what's happening is, when you are filing your labor certification and you are listing out your experience history that shows that you qualify for the job that you're being sponsored for, and you provide the experience letters from those employers, USCIS is second guessing that information when they see information that you've submitted in a DS-160 visa application from years ago that doesn't mention this work or has different dates or different job titles. So you have to be really careful to make sure that all the information you're submitting from your DS-160 all the way through 485 filing is consistent in terms of dates, job titles, job duties. They're looking for any inconsistencies, and when they see any inconsistencies, they use that to cast doubt on the entire application and call into question whether you've misrepresented something either at the DS-160 stage or now. So it's very important to be consistent with that information. We would recommend, if you haven't been doing this already, anytime you fill out a DS-160 for your visa application, print out a copy of that and keep it with you so you have that record, because they're going all the way back years and years. 15 years ago, they're looking at what you submitted then versus what you're submitting now, because many people's immigrant visa process is taking so long. So that would be one thing you can do, is make a printout of that. If you're not sure what you submitted, you could try a Freedom of Information Act request through the Department of State to get a copy of any visa applications you've submitted previously. It may take a while to receive that, so if you're concerned about it, you might want to start that process now so that you have it in hand when you need it.
Question from Veda Vyas. The H4 is not approved, driving license is expiring. They won't give a driving license extension without I-797. What can we do? At least I don't have a solution. Contact Congress. Contact the congressman, US congressmen. Also contact the state congressmen, because in some states they give, in some states they don't. So it's a dual fault there. The two people are hitting you on the head. One is your state that's not allowing. The states could allow you to get a driving license without a 797 approval. They could get it with a receipt notice. So that's one thing that you need to contact the state congressman. You need to contact the federal congressmen to ask, hey, buddy, it's taking so long for me to get the H4 approval. Why don't you make it faster? We want these things to be heard by Congress. As I said, the only thing they look into is this. So if you write the letters, they will be much better prepared to, at least they will understand what's going on. Whether they will do the solution for you or not, maybe, maybe not. But as a community worker, though, I want you to contact. There's nothing else I can do for you, actually. That's all I can do. I can suggest you. If there is any secret formula to expedite those things, you let us know, and we will, we'll be glad to inform everybody else and implement ourselves too. There seems to be that all the expedited processing, contact the congressman, ombudsman, raising the service request, most of the time don't work. There's no solution. At least when you write the congressman, they will be aware of it. They will have a knowledge about it. When the things come in, they may do some things at that point of time.
Anand from Facebook has a spouse with the H4 in progress, and his H1B approved already came through, and he wants to know, can I file an H4 EAD with the H4 application still pending? So USCIS guidance has suggested that they want the H4 to be approved rather than pending. Either they want you to file them together, H4 and EAD together, or wait till you have the H4 approval and then file the EAD. That doesn't mean you can't do it, but if you go ahead and do that, you may get an RFE on the EAD application asking for the H4 approval because they were filed separately. So it might still take longer to get the EAD if you file that way.
Well, just be Rana got the green card on July 1st. Cool, that's so good. Congrats, very happy for you. We received a H4 approval for my extension approval for the spouse. Damn, can they not give it to the Vedvyas and give it to your wife? No, to a spouse. They should. Anyway, what should you do? You're under no obligation to notify. Do one thing, cut it into pieces. You don't need that. Don't show it to anybody to get the driving license or get anything, because that is not a valid document anymore. So just keep it with you. Don't do anything. If you want to, you can tear it into pieces, 1,000 pieces. You don't need that, but don't use it. You are not under any obligation to inform the USCIS. Good question from Jagannath Kesari from Facebook. Rahul and Emily, is there a possibility of retrogression? At this point of time, we do not believe there will be a retrogression of the employment-based green cards until about July of 2022. 99% probability there may not be a retrogression, especially in the final action dates. There is a good possibility there may not be a retrogression until September 30th of 2022. I'm not going to give a percentage. Now comes the question of October 1st of 2022, not 2021, October of 2022 though. If these dumb guys are going to waste the 260,000 plus extra green cards to be given to the Indian nationals, because we are the only people who are waiting for this one, there is a good chance it's going to retrogress. And when it does the retrogression though, even though previously we predicted that once the final action date moves, there is a less chance that it may not retrogress, we changed that right now based on how the USCIS is moving. And if it retrogresses though, some of you people who have filed the 485 application would be there for decades. For decades. For more than 10 years you might be there. Why? Look at it. Go and check the April 2012 final action date says May 1st of 2010. Never it went back. It went back. It never ever came back. It never ever came back to May 1st of 2010 until 2021. Remember, April 1st, 2012, it was May 1st, 2010. Same April of 2021, it touched May 1st. So it took 9 years to come back. Why am I saying it's going to be decades? Last time it was only 9 years. How are you saying it's going to be decade? The reason is that this time Charlie anticipated that it's going to be, they are going to give the green cards to the people. Extra green cards will be distributed. Remember, in the first 3, 4, 5 months, he said he expected all the green cards to be given. Then he immediately changed the story. So if it goes back though, each year 7% of 140,000 comes to be only 10,000. If so many applicants are pending there though, it will be decades for you to get the green card. That's the reason, Jagannath, for you, if you have filed the 485 application, you need to write the letter to the USCIS. If you're anticipating to file the 485, you still need to write that letter. The reason is that the people ahead of in line, if you kick them out to get them the green cards, they all get the green card. You are in front of the line. So it's better that they get the green card so that you have. And if people who have not filed the Perm application, you're in student visa, H1B, why do you need to write a letter? Well, one thing, there are a lot of people ahead of you in line. If those people get the green card, you will be easier. You have an easier chance of getting the green card. For all the reasons, you should write it. I mean, this is the right. Congress has given these green cards to us. The USCIS, because of their inefficiencies, are not doing it. I want you to please contact the congressman. There is a possibility of retrogression. You don't want to be there. Write the letter. Draft is provided at the link.
Sashidar from YouTube, his wife's H4 and H4 EAD are pending, and he's planning to file his I-140 and 485 soon once the Perm gets approved, and he wants to know if she can be included in the process as well. So yes, you can include a 485 for her, even though her H4 and H4 EAD remain pending. Particularly if her current H4 has expired less than 180 days from the time you file the 485, there's no issues for her at all. If it's more than 180 days from the time her current H4 expires to the time you file the 485, you can still proceed to file the 485 for her, but she does need to get that H4 extension approved. So make sure that that extension gets approved so that her 485 does not run into a problem.
CS from YouTube has this question, and I'm going to address Rajesh from YouTube at the same question to asked in a different format though. CS is asking the question, do you still expect the priority dates to move in face of the possibility of green cards wastage? Yes, I do. Whatever dates that I predicted before, it's up to Emily to change her dates. I'm still standing on it. The reason is that the USCIS and the State Department are two separate departments though. The in charge person, in charge department to give the green cards based on the priority date on the Congress is actually given to the State Department. They are the one who moves the dates, not the USCIS. The USCIS adjudicates the applications that are filed within USA. To tell you the truth though, the entire green cards are approximately about 1 million green cards though. So most of them actually go to the family immigration, especially in the preference category of the family immigration. Most of the green cards are actually given by the State Department, not by the USCIS. Surprising to you, I know that. Because in the family immigration, people are outside the country. So when it comes to the USCIS though, they move differently in State Department. And then State Department is also responsible to answer the question, we told you to give the 140,000 green cards and any extra green cards that you give. Why did not you give the green cards to that? Well, the USCIS did not act. Well, make the dates. I don't know. The question can come up. A good congresswoman like Joe Lofgren, these people will ask the question, what were you doing? If they are not giving the green cards, why did not you make the whole dates current? What? Can the State Department unilaterally make the priority date current when the USCIS is not acting? You bet they can. You want to see the history? Go to 2007, July 2007. Look into the priority dates of July 2007. Oops, it'll be so confusing. In June second week, they said the priority dates are current for everybody. On July 1st, they said, no, they're not current. They changed their stories because the State Department was so mad that the USCIS was not giving the 140,000 green cards at that point of time. They just made everything current. No, they didn't move. They made everything current. In other words, if you had a labor certification that was filed in the month of 2021, you could still file the 485 if the State Department takes the same action. That's the reason why there is a possibility of good movements of the priority date. Just because they are going to waste doesn't mean that State Department does not move the priority dates. They still can, could, and should move the priority dates. But I still request everybody that let's stop the wastage as much as we can.
Rahul from YouTube says, I'm on H-1B and my wife is on H-4 EAD, and now I receive my green card EAD. If I use that, will my spouse lose the H-4 EAD since I'm not on H-1B? Yes, so the EAD itself doesn't go away. It remains valid unless USCIS revokes it, but she can't rely on it to work because she's no longer in H-4 status when you are no longer in H-1B status. So she is going to continue to work after that point. After you start using your green card EAD, she'll need her own green card EAD for that.
Vikas Rao has this question, and there's another gentleman who said he has the same question. Sudipta Jana has the same question. I'm on H-1B, my parents have a valid B. What would be the best means for them to travel to USA from India right now? Since they already have the visa, since they do not have the US citizens, they come under the travel ban for the COVID purposes though. So the only thing that they need to is they have to go outside India to some other location that doesn't have a ban, not to Brazil or China, but to some other countries that don't have a ban, and they need to stay there for 14 days, at least 14 days, and they can travel into United States. So it could be any other country, but make sure that country is not banned. I just visited Mexico for my birthday, and when I was coming back, I noticed that they gave a sheet. Have you ever visited countries like India, Brazil, China, and some other countries in the past 15 days? 14 days, they said, they put it, we have to answer no to that question. Of course, I didn't. So if your parents can stay outside the country for 15 days and they can come in, that's allowed. Canada, I don't know if they're allowed to go to Canada, but if they go to Canada and from there they are visiting here, that's allowed.
Voss from Facebook wants to know, can I file the medical directly to USCIS if my lawyer's not sending it without the RFE? Yes, the 485 application does belong to you personally, so you can act on it. And we do have an article on rnlawgroup.com. If you do the search there for for medical exam, you should be able to find instructions on how to mail your medical in rather than waiting for the RFE. And Arun had a question on birth certificates, follow-up question to our video. In my birth certificate, no name is written. Is it okay if I have the school transfer certificate? You can use the school transfer certificate, but you should also get 2 affidavits from family or friends that can confirm all the details of your birth. And we do have an article on rnlawgroup.com with samples for that as well.
It's provided in the link in the video, guys. Natural Yogi has this question. Kid's 485 has been filed right now, and his 485 has been filed a long time ago. Is it good enough that the 485 is reached before the parent's green card is approved? First thing is, why didn't you file it before? That's my first question. You should have filed before. I'm assuming that the kid is about nearing 21, and that's the reason why your lawyer advised you. I would have wasted your money in October of 2020. That's a risk I normally take. I am not that, I don't care about your money that much. I care more about the time and the sensitivity that is involved in. Certain time I risk with your money. Believe me, I do. So you should have filed it. But anyway, answer to your question, once the 485 has been received, and if you did not get the green card, which is a very good thing for you and your kid, they are good enough. Even if the receipt notice comes later on, once it's received, you get the green card, the kid is in good shape.
Sasi from YouTube applied for the H-4 EAD in March and hasn't received it yet. And the spouse changed jobs, wants to know, should I apply for another I-765? You do have the option to do that, and particularly if your spouse's current H-1B approval is expiring sooner, to where now that the transfer has been filed, it should be valid for 3 years from now. If you file that H-4 EAD to get an extra time on your EAD application, number one, it helps you to both have the same end date, and number two, you get the extended validity period at a time when processing times are taking forever. So it is a good idea to do that, but you don't have to.
Arjun Ravis's question, I would expect EB2 to catch up with EB3, but that doesn't seem to be happening. Any thoughts why? Let's look into the history of the Chinese nationals, mainland China, though. It doesn't look like it's all the time EB2 is advancing, though. EB3 also advances. Most of the time EB3 advances, sometimes EB2 advances. It's very hard to predict which one is going to be going forward, though. Although for the until September of 2022, though, most of the lawyers are under the belief that EB3 is going to be more advanced than EB2. Now, I'm not telling that those people who predicted are absolutely right. I'm not telling that the people who predicted EB2 is going to EB2 is going to advance are wrong. This is just majority of the immigration lawyers, and I fall into, most of our lawyers in our office, most, not all, of our lawyers in our office fall into the category who believe in that EB3 is going to be more advanced. But we will see in the coming months how it goes on. Maybe after October of 2022, there may be some changes on it. We may see fluctuations here and there. Although I'll be very surprised though if it happens that EB2 goes much advanced than EB3.
CP from YouTube has an H-4 and H-4 EAD in progress and is traveling back to the US and wants to know, should I update them on my new I-94? Yes, you should. We saw a few cases. We're not sure if this is a new thing or a trend or just a couple of cases here and there. But for individuals who traveled and came back and received the new H-4 I-94, USCIS closed the pending H-4 saying you don't need it anymore. You've gotten an I-94 by traveling. But that caused the EAD to be denied. So I would recommend sending that I-94 in to your both the H-4 and the EAD applications and ask them to adjudicate the H-4 application with this new I-94 number and adjudicate the EAD. And you may want to consider also filing another EAD application just in case that first one gets denied.
Kumar has this interesting question from YouTube. I never received the 485J supplement, though I filed it along with the 485 in October of 2020. It's a straight application, not a downgrade. Should I file it again? No, you don't need to file. We have no clue when they are giving the 485J supplement receipt, when they are not giving, when they are giving, why they are approving for some people, why they are not approving. We have seen people who have not received the 485J supplement, not got the 485J approval, got their green card approval. So you don't have to do anything. I wouldn't do anything at all. I will definitely not file a 485J supplement for you.
Supra Pratim wants to know, can you get a 3-year H-1B extension if your priority date is current, but you don't have the I-140 with your current employer? So if you're relying on an old employer's I-140 to continue getting 3-year H-1B extensions, you can only do that when the final action date is not current. So for some people, now that that final action date has become current, they won't be eligible to get a 3-year extension under AC-21. You can get a 1-year extension under AC-21, especially if you can show that you are working towards the green card process with the new employer. So you should at least be able to get a 1-year extension.
Irshad Sheikh and Balu Reddy has the same question. Using the same labor and using the same Perm labor, they got the EB2 and EB3. Can they file 2 485 application? I don't think so, and you should not, because it's one job and 2 things. That's definitely not. Now, there are some instances where people have filed 2 485, especially if the husband has one, let's say EB2, and the wife has EB3. They filed both as a cross to the wife as a dependent in one case, wife as a main person in the other case, and vice versa in the other case. That's okay. That's perfectly okay. But not using the same permanent labor. I wouldn't advise. What do you say, Emily? Did you?
No, I wouldn't.
I wouldn't advise it.
Srikar Anat wants to know, my Perm was filed in EB2 and expecting the approval this month. Can my company file for the I-140 and EB3 directly, or do they have to file an EB2 first and then EB3? The Perm is, an EB2 Perm can be used to file in either EB2 or EB3 or both. So you do not have to file it in EB2 just because the Perm was designated for EB2. The Perm itself is not designated one way or another. It's just based on the requirements for the position. So it's not necessary that they have to file the I-140 and EB2 and only then file the EB3. They can go straight for EB3 if that priority date is more beneficial to you.
Sirisha Gujula from YouTube asks, can I travel on CPT visa? I'm currently on PhD program. Especially if you are on day 1 CPT universities, no, don't. Because they, in turn, we don't consider the day 1 CPT universities as genuine universities.
Nilesh from YouTube wants to know any updates on Schedule A worker downgrade approvals. Are they accepting it? It's going both ways on this. We're seeing some approvals and some denials. We're seeing some notice of intent to deny and RFEs. There doesn't seem to be any rhyme or reason to it. Very inconsistent.
Questions are coming with regards to the delays in the Perm labor certification. Is it good to apply for a B2 visa and then convert into H1B? It may be advisable to file the B2 visa if you fear that going to your home country might cause some problems with COVID, though. But in general, it's not advisable for you to just linger around in the country so that your Perm and I-140 is approved for you to file an H-1B transfer again. But for the people, especially those people who couldn't leave because of the COVID situation, once their I-140 is approved, they were able to file the change of status from B2 to H1. Some of the people did get the approvals of the B2 to H1. They got their B2 and H1B approved at the same time. But most of the time what the USCIS does is that, hey, since your B2 is still pending, I'm not going to give you the I-94, so I'm going to give you the H-1B approval without the I-94. You go outside the country. In the same scenario where we notice that if it is a H4 though, where the person has moved to H4 though, they did approve the H4 and H1 on the same day. But when it comes to the B2, they didn't do the same thing. They normally waited and they gave the H-1B approval without the I-94.
Mohan from YouTube wants to know, what is the probability of a Perm application being audited and what is the criteria? I would say less than 10% right now of Perms are being audited. There are certain things that do trigger audits. For example, if a company has filed a Perm for you previously that was denied and they are filing a new Perm for the same person, that second Perm generally is audited if it's filed within 1 year of the previous denial. One of our attorneys, Crystal Alanis, she's the managing attorney of our Perm department. She actually has an article on rnlawgroup.com that talks about Perm audit triggers, so you may want to check that. If you go to our website, in the search box, look for Perm audit triggers.
Jagannath Kesari has this question though, is what is the advantage if we just file the 485 and the USCIS wastes all the visa and we have to wait on the 485 application for a lot of time? First thing, I hope the USCIS does not waste. There are two-pronged approach that we are taking. One is to make all the dates current, and the second one is to get the USCIS approve and use the numbers though. There are a lot of people, there are not a lot of people, I would say. There is some organization, one or two culprits, that keep on posting on our Facebook and YouTube saying that we are the evil people that want all the people to delay. I don't know where they come. That idea, they cut and paste pieces of what me, Emily, and certain other people have spoken and said that we are against 485. I don't know where they got that idea. But they cut and paste, and we know which organization it is. They're making money on using our faces as the demons. They cut and paste those things. We know who they are. But anyway, coming to the point, you have a good question, Jagannath. What advantage would you get if you're in adjustment of status and your priority date backlog and you may have to wait for decades on the 485 application? Definitely, I would like you to get the green card over staying in the 485 application. But staying in the 485 as compared to maintaining a H-1B has a lot of advantages. One is that if you want to change the company from one company to another company, you file something called 485J supplement. It's an easy application. You don't need end client letter, you don't need vendor letter, you don't need a lot of documentation you need for the H-1B. And Jagannath, you know what the filing fees for the 485J supplement is? $0. Then comes the question of EAD and advance parole as compared to maintaining the H-1B and H-4. USCIS has recently said that they are not going to approve any more 1 year EADs. It's going to be only 2 years EADs. So when you apply for the EAD and advance parole extensions though, you don't have to go to your employer to file it. You can do it by yourself. And guess what the filing fees is? The filing fees is, it's zero. It's zero, really. Filing fees is zero. Can the filing fees for EAD be zero? Yes, it is. Only for the adjustment of status 485 EADs, not for H4 EADs, not for 100 different EADs. Only for the adjustment of status. Thank for Prakash Khatri, who was the first ombudsman, good friend of me, and he's the reason why you don't have to pay the filing fees for advance parole and also EAD. And while the EAD extension is pending, you can work for a company for 6 months. And for you and your wife, your spouse, I mean, they can do anything they want on EAD. They can flip a burger in McDonald's. They can be a Microsoft CEO. They can be a lawyer like me. Oh, believe me, you know, I was a lawyer on EAD, Emily. I was a lawyer, Jagannath. Let me explain to you. Yes, I became a lawyer. I even went to the 485 interviews on a EAD, not as a dependent, but as a lawyer. And the client asked me this question, Rahul, when did you get the green card? You know, Jagannath, what did I answer to him? I will tell you after the interview. The reason I told him is if I tell him that I did not get the green card, he may run away. My senior lawyer sent me, so I went there. So after the green card is over, he said, "Let me take you a nice dinner." He took me a Red Lobster. It was an expensive dinner for me. And then he said, "You told me that you will tell me when you got the green card." I said, "I never got the green card." So yes. Your spouse could be doing can be doing any job in EAD. So these are all the real benefits. I was there. I became a lawyer on EAD on adjustment of status. So I'm a direct beneficiary of working on the EAD. It's very simple. So it's easy to maintain those things. That's the reason why being an adjustment of status is better than H-1B. But obviously, there is nothing better than green card, though. There's no doubt, nothing better than the green card. But the comparison from H-1B comparison, your EAD, you're far better.
Androsius from YouTube has a good question. My I-140 EB3 downgrade was approved July 2nd. Priority date is current, July 1st this month. Apart from fervent prayer, is there anything else I can do at this point? Well, you've gotten two things done, which is great. So we've talked before that your I-140 has to be approved and you need to have your final action date current. You also need the biometrics. So if you haven't had the biometrics done, there's nothing in your hand that you can do to force USCIS to give you the biometrics other than trying a service request online. To get that done, you can try to chat with Emma to see when you might be scheduled for your biometrics. The last thing is the medical. If you did not submit the medical when you filed your 485, you can do that interfiling now. Review your 485 application to see if anything else was missing, anything that you need to submit. But otherwise, it's just a waiting game at this point. Until it's outside normal processing time, you're not able to really do anything to speed up the process. And because normal processing times are ridiculous, there's not really much you can do.
Vamshi Krishna has this good question that he wants to interfile the medicals, but the USCIS lost wife's receipt. If you have the receipt number, which you could get it from the check cashing, you can even speak with Emma. Emma gives check cash your receipt notice. If you have that receipt notice number, you can go to the USCIS site. You can punch in that number. It says that your 485 is pending. You print that and use that as a receipt notice. Anywhere you want to use a receipt notice, use that as a receipt notice in sending the medicals. Sam has this question. Eagle Act, what about comment about it? At this point of time, we want you to take some action on the things that are actionable. That means that your letters might be more helpful. So at this point of time, we want you to write letters for using this 120 or 130,000 green cards plus 150,000 green cards. When the Eagle Act comes to a stage where it requires a push from us, at that point of time, we're going to give you the drafts of the letters for you to send it. We don't want it is at the initial stage right now, going around in circles there. If you write the letter at this point of time as compared to when it comes near, we suggest that doing it at the time when it makes a good impact. Please keep following us on the YouTube and Facebook. We will update you when the time is right for you to write a letter to the Congressman and contact the Congressman.
Indranil from YouTube has an H-1B approved with consular processing, but is in the U.S. and can't travel to get the visa stamp. What are the options? So if the same employer that has that consular processing approval wants to, and you are maintaining whatever other status you are in the U.S., then that employer can file another H-1B that is CAP exempt and request the change of status from your current status to H-1B while you're in the U.S. But it does require the employer, they have to refile the whole petition, pay all the filing fees again, everything's going to be re-adjudicated.
Bhaskar Rao has this question, which I missed out actually. How does making current help USCIS? I don't know the exact question, but I think so. He's speaking about help us. One thing is that last time when the State Department made everything current, though, in the 15 days, they adjudicated so many green cards. So at this point of time, the State Department can do either thing, make it current for everybody, well, good. The second thing, even if the State Department threatens the USCIS that they're going to make it current, that's going to be good enough for us because they're going to adjudicate all the green cards because they don't want all these 485 applications. They don't want all of you guys keep on getting the EADs and advance parole for free. Instead, they'll be getting your premium processing fees, your filing fees every time you change the company, your H4, your wife's EADs, and their extensions, their biometric. Oh, biometric has been removed, sorry. But all those fees, they like those fees. If you file the 485, there's no filing fees you will be paying. Even if you want to pay, there is nothing there. So they like your fees. So they don't want you to file the 485 application. So even if the State Department threatens the USCIS, look, we have to face the Congress, you have to give the green cards, otherwise we're going to make the current. Believe me, the green cards are going to be approved just like that. And if they don't act, let them make current, and we are going to, you file the 485 application, you are free for your life until you get the green card, so you don't have to pay any, at least the filing fees to the USCIS. Before we go, I just want to comment, thank you for all the good wishes that we get it from you guys. We're very pleased, but we want to mention that we are not YouTubers, guys. We're not entertainers, we're not YouTubers. We are practicing immigration lawyers. So if you want to speak with us, you can always make a consultation for us. And if you want to seek our help with regards to filing your, pre-preparing your 485 application, there is a link we provided. We have provided you all the links and the useful links that are provided. Use those things. But once again, thank you for all the best wishes that you do. Thank you. Thank you. Anything else, Emily?
Yeah, and please make sure to subscribe to our YouTube channel. And if you are watching on Facebook, make sure you check the box to receive updates and notifications on when we're live so that you can always catch us every Tuesday.
And any reviews on the Google, we really appreciate it. We are in Houston. Houston immigration lawyer, you find out as Reddy Neumann PC. We like reviews on the Google. Thank you very much.